Hi, everyone. My name is Sharon Amir, and I am a partner at Naschitz Amir. The topic of this panel is hostile takeovers in general and in the technology space in particular. With us here in the panel, I'd like to introduce first the guests, and then we can talk. We can start. So, Warren Taylor. Warren is a corporate partner of a global law firm, CMS. Warren was a partner of the law firm Nabarro for 16 years before its three-way merger last year with CMS, Cameron, McKenna, and Olswang to create one of the largest law firms in the world with 74 offices in 68 cities and 40 countries. It has over 4,500 legal professionals, and it's the #1 law firm by deal count for M&A in Europe. Warren is based in the London office. His focus is M&A, takeovers, equity capital market transactions, and a particular focus on life science and healthcare sector. Throughout his career, he acted for a number of Israeli companies and their investors in transactions in and out of the UK. So Warren will help us in understanding what's going on in the UK with respect to hostile takeovers. Dr. Mathias Reif. Mathias is the executive partner of DWF's largest German office in Köln and heads as the lead corporate M&A partner of Germany, the German corporate and M&A practice. He works predominantly on cross-border agreements as well as national and international franchise and trade agent agreements. He has more than 18 years of experience in national and international mergers and acquisitions, joint ventures, squeeze-outs, restructurings, with a special focus on tech and media. He is also the global head of DWF's Israel desk and has extensive experience in handling corporate transactions for Israeli clients in Europe. So he will assist us with continental Europe. Barak Platt, sitting next to me. Barak is a partner of Yigal, Arnon and Co. He specializes in M&A, high-tech, VC, and PE transactions, private equity. His clients range from multinational corporations, including Intel, which is recently represented in the acquisition of Mobileye, to startups and VC funds. He studied in the US, where he received his law degree from Berkeley and has since practiced in both US and Israel. So since we don't have a US participant, maybe he can assist us here too. Yechiam Cohen, on the far right. Yechiam has served in the past 22 years as general counsel for two of Israel's leading tech companies. From 1996 to 2004, he was general counsel of Amdocs. And from 2005 till the last day of December 2017, he was a general counsel of NICE. Prior to that, he was a partner at the Tel Aviv firm and worked in New York for 4 years. So now you know everyone, and we can start. Since I don't know who the audience is and what your background is and whether and how much you know about hostile takeovers and what they are, I will start with a brief introduction, and for those of you who I'm boring, it will be very short, okay? So to lay the ground rules here, a hostile takeover is the acquisition of a target company without the acquirer receiving the support of the target's board. So the board of directors of the target company doesn't like the acquisition, and the acquirer attempts to acquire the company. Obviously, this can't be done in the form of a merger, which is the typical way in which companies are acquired in Israel and elsewhere. Usually it's a reverse triangular merger is the most common way. It can't be done through a merger because a merger requires the board to support it. It requires a majority. In Israel, for example, it requires a majority, but in every country, it requires the board to approve the merger, and it requires, and the agreement is between the two companies that are merging, so obviously the board has to approve it. So you can't do a merger. So what can you do? you can do either a tender offer to the target's shareholders, which is going above the board, above the board's head, going directly to the shareholders and saying to them, come and give us your shares and we will give you money or stock or whatever the consideration is. So this is one way of effecting a hostile takeover. The other way is to replace the target's board, because if the target's board objects to the merger, to the acquisition, one way of doing it is replacing the board. The way to replace the board is to solicit, through a proxy fight, to solicit the shareholders of the target to replace the board. Okay, so these are the two ways that are the most common ways of acquiring a company when it's a hostile takeover. The Delaware court accepted several years ago now the poison pill defense, which basically is a rights offering, a rights issuance, to everyone but the hostile acquirer. So the board issues rights or shares or rights to shares to each of the shareholders who are not the hostile acquirer. What happens in this case is that the hostile acquirer is diluted, because if he wants to acquire the company, but in a tender offer, and he starts acquiring company and he gets 50%, but then all the other shareholders get rights or shares, so that now he's reduced to 25%. It obviously doesn't make sense for him to even start. So there are questions around the world, and we will hear about it more later, about whether this poison pill defense works. In the US it works. Once it worked, once the Delaware court accepted it, what it meant was that the whole issue of a tender offer is gone, because no one would do a hostile acquisition through a tender offer if the board can activate a shareholder's plan or a rights or a poison pill and basically get rid of the acquirer, and he will lose the money he put in. So what happens is that this way of effecting an acquisition is basically ceased to exist after the poison pill was accepted. For a while, there were companies without poison pills, and there was a question whether a board can initiate a poison pill in the midst of a hostile acquisition. But even then, the Delaware courts ruled that it can. So now, it basically killed this hostile takeovers through a tender offer. So what's left? Only this, in the US at least, only this proxy solicitation or trying to solicit votes with the shareholders of the target to replace the board of the target, or trying to put pressure on the board of the target to agree through other means. For purposes of this panel, we will also refer to another similar mechanism that is not really an acquisition. It's not a full acquisition, a full hostile takeover. It's a shareholder activism. Because why is it similar? Because shareholder activism is also something that is opposing to or is contrary to the board's wishes. The board doesn't like the activists to come in and to shake the company, and the fact that shareholder activists come in is something that is similar to hostile takeovers, but it's not a hostile takeover because it's not 100% acquisition. We will touch on this as well, just because there's not that much to say about 100% acquisitions. So now, having given you a few words about what a hostile takeover is, let's talk a bit about technology. In the past, conventional wisdom was that technology companies cannot be targets of hostile takeovers. Why can't they be targets? Because, first of all, their only assets are intellectual property and the brain power. So one of the basic themes of a hostile takeover in the past that was to strip the assets of the company and make more money then the company itself cost by stripping the assets doesn't exist when the assets are brain power and intellectual property. There aren't many assets to strip. You can't sell the brain power. Another thing is that employees that don't like it can jump ship. So that also precluded hostile acquirers from approaching technology companies. And third, but not least, was the high multiples in the technology world, because in the technology world, the multiples were such that were disproportionate to any real earnings, so it didn't make sense for a hostile acquirer to buy the company if the board didn't support it. Recently, this went some changes. One of the biggest hostile takeovers currently in play anywhere is Broadcom's attempt to acquire Qualcomm, which is approximately $120 to $130 billion of a hostile takeover. The Qualcomm board is against the acquisition, and the Broadcom is trying to acquire the company and has done several things in order to do so. Now, what happened? First of all, the rate of revolutionary changes in the chip business has slowed down. There's more price competition. It results in lower margins. And industry begins to look more and more like traditional industry. So the technology industry is becoming more and more like traditional industry. So this can lead to technology takeovers or hostile takeovers that we see more and more. Similarly, activism in the technology world that in the past was non-existent became something that we see everywhere, including in Israel, by the way. If you notice, now you see Mellanox struggle against Starboard, which is an activist fund and wants to replace the board. Mellanox, by the way, struggled when it acquired EasyChip. Again, there was a struggle there against Raging Capital, that was a shareholder activist that objected to the acquisition. So you see more and more of this. So with that in mind, with this brief introduction, let's go to the panel itself. We will start by really looking at, before we touch on targeting Israeli companies in particular, I'd like each of the non-Israeli participants to give a short presentation of the current legal framework regarding hostile takeovers in your home countries. I'd like to focus first on the viewpoint of the acquirer before we talk about the defense. So let's start with the acquirer. Warren, what is it like in the UK?
Okay, there's a couple of basic principles that everything is going to be based on. Firstly, that the basic set of rules is the UK Takeover Code, and the UK Takeover Code applies to companies that are registered in the UK and the Channel Islands, whether their businesses are overseas or whatever. They're listed on the UK market, and they are registered in the UK. The UK Takeover Code applies. If they are just listed, but they are registered overseas, then most of what I'm going to say doesn't apply in terms of the rules. Now, there are a number of companies that are listed in the UK that have tried to incorporate some of the Takeover Code principles into their constitutions, mainly in relation to items such as stake building and limits up to beyond which you are forced to make a bid. But most of the Takeover Code principles only apply to UK companies or UK registered companies. So a lot of what I'm going to say is based around that. The UK Code is based around a set of principles. There are 6 basic principles and a number of rules. There are practice statements around it. There is a huge amount of experience and case law and things that are behind the rules, and for that very reason, the Takeover Panel, which looks after the rules, are very keen for all bidders, whether they want to go hostile or not, to get advice and to take independent financial advice from an investment banker, sometimes lawyers, although the Takeover Code has a bit of a wariness of dealing with lawyers for whatever reason. But the principles include things like equality of treatment, the fact that target shareholders have sufficient time and information to consider terms, that the target board must not deny shareholders the ability to decide on the merits, but on the other hand, an offeree must not be hindered to conduct its affairs for too long. Now, those sort of basic principles, those were four of the 6 principles. It is relatively, I think it's relatively easy to conduct a takeover in the UK, in terms of there are not many ways that you can resist at least putting an offer to shareholders. Unfortunately, we have just very recently, in fact, actually a couple of days ago, the leader of our opposition actually decided in a speech to one of the trade unions, is looking to potentially make it harder to take over UK companies, to protect the sort of industrial base of the company of Britain. So that might eventually, in a change of government, might make it harder. But at the moment, it's relatively easy to at least try and put an offer to shareholders. But it is not easy, and hostile takeovers are not that common. One thing why it's not easy, availability of information. Clearly, if you are not, you haven't got the target on board, what information is there to do due diligence? There are public registers, there are obviously trademark registers, patent registers, there's institutional research, there are the public announcements, accounts. Public companies must publish their shareholders of 3% or more, but they are not obliged to publish the shareholder register in general, although you can make a request for it as long as you give a reason why you're making that request. Secrecy is absolutely fundamental. A core principle of takeovers in the UK is secrecy. Now, obviously, if you are a hostile bidder, you don't want to show your hand too early. Now, the Takeover Code does require, in certain circumstances, for announcements to be made. So, after a potential offeror has started actually considering a bid, and when that actually happens is a matter of fact, but it can be much earlier than you might otherwise think. After that point, but before you make an approach, you might need to make an announcement which would name the offeror. If the target is subject to rumour, speculation, there is a share price movement, and there is something to connect that activity with the offeror's actions. Now, if you can show that, maybe because there's been a leak of information, then the offeror might be obliged to make an offer. Before you do make an offer, before you make the approach, not make the offer, before you actually make an approach to the target, you have to, the obligation to make an announcement is with the offeror. So an offeror, even though it might not have spoken to the offeree, has to keep an eye on the target share price. If they see a movement in the share price and it's potentially linked back, it is the offeror's obligation to make that offer, whether or not it's hostile. So once if you're forced to make an offer, you've got 28 days to effectively put up or shut up. So you can't, if you're forced to make an offer, you're tied to 28 days to make a decision. Now, obviously, that announcement can be of benefit because it can flush out your chance to speak to shareholders. Otherwise, you are very, very limited. A bidder has got a very small number of people it can approach before announcements are due. Now, that includes its own financiers, if it wants to talk to people who want to finance the bid. there's effectively any more than 6 people outside immediate advisors, then you are obliged to make an announcement. And one final thing in terms of what a shareholder can, a bidder could do. You can obviously stake build. There used to be quite tight restrictions as to how quickly you could stake build for a UK company. Those rules have gone, but you are still limited to 30%. If you get to 30% or more, you are obliged to make a bid for the target company. And once you are at 30, anything between 30 and 50, any new shares you acquire, you again are obliged to make a bid. So it effectively stops you acquiring shares that are above 29.9%, but up to that point you can make a bid, subject to insider dealing provisions and things like that. The one last thing in terms of activism, 10% allows you to call a general meeting. Anecdotally, in terms of general meetings in the UK for public companies, there is something like between 40 and 60% turnout at general meetings for UK companies. So a 10% stake can actually give you quite a lot of influence.
Thanks. Matthias, how is it in the continental Europe, Germany?
Shalom. Warren, thanks a lot for saying all that, because despite that a few people want to change that, currently obviously UK and Germany are in the European Union, and that you can see already from what Warren already said, a lot of the points I could actually just repeat, because the rules all based on the same European Union regulation from 2003. So in Germany, whereas in UK, obviously you have the UK takeover code, the German one is the German Securitization, Acquisition and Takeover Act, or I can say that in German, but it's not going to be so good then. That is the main set of rules that you need to have in mind when talking about German acquisitions. The second one is the German Securitization Trading Act, and then obviously the Stock Corporation Act. Now, on the German Securitization, Acquisition and Takeover Act, there are eventually, it's a little bit more strict than compared to the UK. If you have about 3%, and then it goes on to 5%, 10, 20, and 15, 20, and so forth, there's a mandatory information. So stake building, yes, you can do it. And again, like in the UK, 30% is the magic number. But unlike the UK, as I understood from Warren, you need to inform, or the company needs to inform once somebody has built up to 3%, 5%, and then so forth. And you may have heard that just a few days ago when you had the Chinese investor actually acquiring about 9% in Mercedes-Benz. Now, this is the information part. On takeover, and again, the 30% is the magic number in Germany like in the UK. Once you reach 30%, you're mandatorily forced to make a bid and an offer to everybody. You can obviously do that before, so if you have no stakes or just a few, you can have a voluntary offer to all shareholders, but with the goal to acquire at least 30% or more. Now this offer is subject to certain rules, obviously. For example, you need to inform the BaFin, which is the German regulatory body, in advance, and they have 10 days to make comments, suggestions, etc. And this offer, for example, has to have a minimum price, which, and if I would start the calculation here, it's going to take us throughout the whole panel. But you can take away, it's about the average of the last 3 months of the stock price. That is about the minimum price that you have to offer in your bid to take over the company. Now, obviously, you would normally offer at least the last stock price traded yesterday, or whenever, unless, of course, you don't want too many people to agree to you. We had that situation when Porsche wanted to take, or had to take, give an official bid to the Volkswagen stakeholders. They didn't, however, want to acquire all the shares. They were forced to do so. So at that time, they offered the average of the last 3 months trading, but that was below the last stock price. Again, that was a special situation. Normally, if your goal is to acquire the company in full, or at least 95%, which allows you a squeeze out of the last remaining, then you obviously need to go above that. Now, we'll talk about in a minute about what are the defense situations from the acquisition or from the acquire perspective. Again, the offer that you're going to do has to be on the table for at least 4 weeks. That's the minimum, and up to 10 weeks. That's the max. If after this period a certain threshold has been achieved, that to say stakeholders accepting your offer, then actually there's another 2 weeks which the remaining shareholders who did not accept your offer in this initial period then have another go to accept, to jump on the bandwagon actually. So often, you know, and you're nodding, you have the same experience obviously, often you have shareholders who just wait and see how the whole thing goes, and then, you know, they are secured that they have another 2 weeks to accept and not left behind and maybe squeezed out by, you know, a small portion. So that's one thing to remember. And again, the next one is, and you mentioned it with regard to the opposition leader, obviously in Germany, like in every country you may say, also in the US, obviously, you have certain sectors that are restricted, where the government wants to have a say before any of these companies from this sector would be acquired. Namely, in Germany, it's bank, it's insurance, and all that. It's quite limited. It's not a quote-unquote secured country where, for other reasons, lots of companies are out of the play. And you may have seen that. When was it, like 2 years ago or something? Last sentence, there was a very interesting technology company from Germany being acquired by Chinese, and lots of people actually were really afraid that this is going to be the sellout of the German technology, so they were asking to have limitations on that, but however, didn't happen, so you have very limited sectors where you need governmental approval.
You don't have CFIUS. Okay. Now let's turn to our focus to Israeli companies. Barak, in what ways do you see the situation in Israel different from what we've heard here?
Well, I think you used the term poison pill earlier, and in Israel there's some question as to the enforceability of a poison pill, but arguably Israeli law provides for a statutory poison pill, because the only way to acquire 100% of a company in a hostile takeover in Israel is through tender offer, and the thresholds are extremely high. So in order to get 100%, you need to hit 95% of the shares, and not of the shares voting at the shareholders meeting, but 95% of the issued and outstanding shares. And if the acquirer has any type of personal interest in the target company, then you also need 50% of the disinterested shareholders to vote in favor of the transaction. So that in and of itself is a threshold which is extremely difficult to achieve. And in addition to that, the law provides that even if you hit those thresholds and you consummate the tender offer and you buy 100%, the shareholders who didn't vote in favor of the tender offer have 6 months to go to the court and argue that the price paid in the tender offer was not fair. So it's a difficult there are difficult thresholds to really satisfy, and I think it's one of the reasons we don't see a lot of tender offers here. In the technology sector, I would say it's additionally complicated, because it's not unusual that you have founders of technology companies who retain holdings and sometimes significant holdings in the companies. And so if they are not supportive of a transaction, that might, in and of itself, render the 95% threshold unattainable. There are other ways of getting smaller interest. I mean, the Israeli law provides for special tender offers, so if you want to hold up to 25% and there's no other 25% holder, you can go ahead and buy them out, but
Above 20.
above 25%, and same thing with 45%. But again, looking at buying control or 100%, which is typically desirable, of a technology company, the only way of really achieving that in Israel is through a tender offer or obviously a negotiated transaction.
Okay, you mean through a merger? Yeah. Okay, you said tender offer by mistake.
Oh.
Okay. Yechiam, you've been an in-house general counsel of both Israeli and non-Israeli public companies for many years. Do you find differences in the way a non-Israeli company prepares its defense against a hostile takeover and an Israeli company?
Yes, I think, you know, the two of you, Barak and yourself, fully familiar, Israel is unique. As much as we think we are part of, you know, the Anglo-American system, and there are very special rules that apply only to Israeli companies, and some Israeli tech companies really use it handsomely. I think the foremost important one for those who are not familiar with the Israeli corporate structure is for a public company, you have to have what we call dachat, which is the short version in Hebrew for external directors. And these are directors that are appointed for a 3-year term and cannot be replaced. So even if one undertakes a tender offer, you know, you cannot replace these external directors. And the minimum is 2, but there's no cap. So one of the practices in some Israeli tech companies is to have more than 2 required external directors, which is a very nice way to bolster, you know, I would say control of the company, because they act as a shield against any, you know, unconsensual acquirer. The second one is, you know, like especially, I'm going to talk about 2 of them, is, you know, there was a guy who talked about innovation, but he came from a chief scientist. Chief scientist gives a lot of money to tech companies. It's, again, you know, talking about tech, and they have their own rules. And sometimes, you know, my colleagues here can share war stories about transactions that cannot be completed because of issues with the chief scientist and issues with the export of the technology. And if you're buying Israeli technology, most likely, especially by a big company from out of Israel, you very much would like to export it and use it out of Israel. Sometimes it's not doable. The other aspect of export is not something many people are familiar with, is we have control rules about, you know, that actually control almost the entire tech companies, not used very often, but, you know, the export control that's actually meant to protect, I would say, security interest of certain companies. And you can be a public company selling, doing great deals altogether, but a transaction can be blocked by the government if this technology is used by, I would say, for security purposes and others. So this should be taken into consideration. And it's, again, it's really special for tech. I'm not going to talk about what happens, you know, in many other companies, like staggered board, very popular in Israel, for tech companies that go public and get smart advice by lawyers before the IPO. After the IPO, it's almost impossible to pass that, but before the IPO, it's a very, very good defense, and it really takes time for the acquirer to, you know, to do a takeover. People discussed the poison pills already. There are 2 other things that I want to mention. One is, first of all, you know, talking about, you know, tender offer. Israeli institutional investors tend to be very patriotic, and in that should be also taken into consideration. Of course, money is important, but this is an aspect that should be dealt with. And put, we can put this with the last fiasco of Teva, and I hope there's no one from Teva who, but this raised also major issues because the government put billions of shekels, let's call it this way, into Teva this way or another, and there was a lot of public pressure after Teva only decided to lay off some people. Think of what would happen if some company comes over to Israel and decides that, to acquire Teva and take all the business and I would say manufacturing out of Israel. So again, this is a consideration. I think it's not only related to tech, but mainly tech because this is where a lot of the money goes to from the government. The government doesn't invest in insurance companies or banks or whatever. So I think
there it can stop the acquisitions.
Yeah, this is a regulated industry. The good thing about, well, the good or bad thing about mainly the tech company, the tech industry for itself is not regulated like the banks and the insurance companies.
Thank you. Now, Warren, you mentioned before that you were talking about UK companies that are registered and traded in the UK. What about Israeli companies that are traded in the UK? How are the tender offer rules that you've described before, how do they apply? Do they apply?
Basically, no. They don't apply because, as I say, it only applies to UK registered companies. So there are certain provisions of those regulations that are often on the listing incorporated into the constitution. So, as I say, things like the limit of 30%, requiring if a bidder acquires more 30% or more, they're obliged to make an offer, and a couple of other rules, but the basic principles do not apply to Israeli companies. So you are down to your very sort of quite common defences, being organised, being on top of the holdings, being familiar, having the arguments about valuation and continued independence, being close to the opinion formers and shareholders. So it's those sort of tactics that you would have to you'd have to follow. There's a couple of things on the difficulty of of UK takeovers, and one of the points about the thresholds, which in some respects mitigates against stake building. We also have, if you have to have an acceptance condition which is acquiring 50% or more. Most bidders will have that acceptance condition. If you want to take over 100%, you have to reach 90%, and then you can squeeze out the rest. Now that 90% is 90% of the shares to which the offer relates, and the shares to which the offer relates does not include any shares held by a bidder. So if a bidder has built a stake, they are effectively making it harder for them eventually when it comes to making the bid to acquire the 100%. Still possible, obviously, but you are 90% of a smaller amount. There are two basic principles in the sort of UK under the UK regulations. One is, as I've already mentioned, the requirement to ensure that target shareholders do have an ability to assess the merits. But there is also the general corporate provision of acting in you have to act in a way that promotes the success of the company. And that is looking at it from the shareholders' perspective. And that's not just shareholders today, but that's also potentially shareholders going forward. So a board in the UK has to consider all of those aspects. So there are certain things that they can't do, that you cannot frustrate a deal. So we talked about poison pills. Technically, a poison pill is possible, but it's really, really hard and really, really frowned upon, certainly by institutional investors in the UK. You can have it if a board genuinely believes that what they are doing is promoting the success of the company for now and for the future, then there is an argument that a poison pill could work. They are incredibly rare and frowned upon. You can also not technically have, you cannot frustrate a bid under the UK Takeover Code. So you can't, once a bid has been, once an approach has been made, or you are, you believe, a target believes that one may be imminent, they haven't been approached, but they understand it may be imminent, they can't do certain acts. They can't issue new shares, they can't acquire or dispose of material assets, and material assets is something around, is a 10% test. They can't enter into contracts outside the ordinary course. So you couldn't, for example, a board couldn't amend their own service agreements to make it harder to add sort of penalties or poison pills into that without shareholder approval and bidder consent. So there are really quite difficult steps to get over if you wanted to frustrate a bid in the UK.
Thank you. Matthias, I'm not sure there are a lot of Israeli companies listed in Germany, but how is it in continental Europe? Would an Israeli company listed anywhere in continental Europe have any hostile acquisition be governed by Israeli law or by the local law?
Well, it's a little bit like Warren described for UK. The German code applies to companies listed in Germany and registered in Germany. That's number one. Secondly, but then again, not on all parts, on companies registered in the EEA, so that's more than the European Union, but you know, the bigger circle, and listed in Germany. And it actually applies, but seriously only in parts, and I think what Warren described from the UK is a rough overview also what you have in Germany with regard to companies like Israeli companies listed in Germany but registered in, let's say, Israel in this case. Again, prerequisite here is that they are not listed in Israel. So an Israeli company listed in Germany and listed in Israel, that would not, the German Takeover Code would not apply. Now, for the ones, so the core ones are, honestly are listed in Germany, registered in Germany. For those, and as Ron was describing regarding UK, and let me very briefly tell you what the defense mechanism also are in Germany. And I said that earlier before we went on stage here. Funny enough, Germany is less restricted or less difficult, so to say, for hostile takeovers than, for example, in the US, because poison pill, something that you guys in the US at least, love a lot. I understand, and I'm definitely not an expert, but flip over provisions and all that in the US, that all doesn't work in Germany. Not necessarily because of the German takeover code, but because of the German stock corporation code. And that, I could go on, but I spare you of the details, but that has something to do about the shares being equal, and you can't have different classes of shares and all that. So the nice poison pill thing, that is off the table here in general. So what is on the table is white knights. That works. You can always go and try to find somebody else. What is also off the table, for example, you can't have a Pac-Man approach. You can't, make an offer acquiring them if they want to come to you. You can't change your contracts for some, adding some nice change of control clauses with your main customers or suppliers. That's not going to work either. In general, Section 33 of the German Takeover Code principle says you cannot do anything that is capable to prevent the bid, very, very much quote unquote. What you can do, obviously, are all actions that a prudent businessman would do. Obviously you can't just stop running your company. You can do white knight approaches, as I said, and then here's the fun part. You can actually, in your articles, you can opt out of this Section 33. So my advice to you guys, if you're planning a hostile takeover in Germany, check the articles first and see what it says in these articles. Now, because if the company opted out, they have a little bit more flexibility in their defense mechanism than the companies who did not opt out. Again, poison pill doesn't come from Section 33, so that doesn't help you. Okay, you want to say? So So the two things that you can do as a German company, if you're in a hostile takeover position, is then, or Israeli companies, so to say, then that's, you can do everything that you agree with your supervisory board. You may know in Germany you have different levels. You have supervisory boards, management board levels, and so on. And you can do everything that the shareholder assembly has agreed in advance to the bid. So nothing, you can't just call an assembly then after the bid was on the table, but everything that was before the bid, that can also be done, and that is but that has an 18 months limitation to that. So you do have some options, not all of them are from the US, but you're not totally helpless. So it's a game.
Just want to add one thing. What white knights also apply in the UK. The one thing that it is very important to know is that if you are providing information to any potential bidder or bidder, you have to make that same information available to all bidders. So if you were looking for a white knight and you wanted to provide due diligence material, you are then potentially opening up all of that information to your hostile bidder as well. So that in itself is something that's quite important.
Thank you.
Just one sentence, that's a good one. Thanks for mentioning that, Warren. What German companies often do is just limiting due diligence information, because the less they know, the harder for them is to make a bid. And that's on the table, that is within the 33 section that I mentioned before. Sorry.
The foreign lawyers here are hostilely acquiring this panel. So let's go for a second to Yechiam. Do you see now, we understand that there are difficulties in acquiring 100%, but when we talk about shareholder activism, and it is more prevalent today, do you see companies planning against these types of activism? What kind of defenses do you see?
I think that, like if you look at the Israeli companies in general, we all know there are some cases of, whether they're not even incorporated in Israel, but if you would recall, Converse at the time had, like I would say an activist that eventually put 2 directors on Converse board, if anybody was following Converse at the time, now gone. So I think everybody in Israel is aware. I can quote at least one of my former CEOs, and I won't mention the name because you can guess. The guy said, I don't want anybody of that kind of people coming knocking on my door and said, hey, nice to meet you. I hold 19.9%, which is the threshold in Israel, of your shares. And I'd like to sit on the board and I have this kind of plan. So I cannot say that the CEOs ignored it. Their nightmare is that to have one kind of, I would call it an activist, which is more popular in the United States, now getting more popularity in Israel, or I would say any kind of a venture company in Israel that like to have influence on companies that do not have a controlling shareholders. So this is a major concern. At the time, we tweaked a little bit with the bylaws to get some, time to react, because this was the, like if somebody knocks on the door and said, well, I'm your partner from now. I'd like to have seats on the board. And okay, what do I do now? But I think recent legislation and recent court ruling in Israel minimized the situation. See what happens now with Teva and Bezek, all the pressure, I think more Bezek now than Teva, that pressure to have another General Assembly of Shareholders to appoint new directors. All of this, is the major concern. We tweaked with the bylaws. I'm not sure it will withhold in court, but we, at least one company that we adopted some regulation from actually the text from New York Stock Exchange rules, hoping it would, it would stand in court. As I said earlier, you cannot change, if you have a regular board, you cannot change it to a staggered board. You're not going to get the support from, you cannot get the poison pill if you need the support of a General Assembly. So at the end of the day, I think people are concerned. People think of, we have sort of a drawer, plan in the drawer, or what do we do if somebody knocks on the door? But I think the best achievement for a tech company is to have its share price so high, so it's going to be so costly for a bidder to take over, And honestly, If he doesn't, then why not? You know, like.
Right. Barak, the last question today. What do you see? Do you think Bezeq and Mellanox are the beginning of a new era, or just sporadic occurrences?
Well, I think shareholder activism is something that Israeli companies have not had to deal with much in the past, but I think it's here to stay. I think it depends on the circumstance. I mean, I think if you look at Mellanox as an example, you have an example where there was a company that Starboard thought was underperforming vis-a-vis other companies in the same industry. So the fact that Mellanox is an Israeli company, I don't think had any relevance or interest to Starboard. So I think Starboard came in and said, we're going to take a meaningful stake and we're going to apply some pressure and try and get this company to turn around. Mellanox may be a little bit unusual in the fact that there was no controlling shareholder. And there are still controlling shareholders or significant shareholders in many Israeli technology companies. But I definitely think that we're going to have activist shareholders out there looking around and seeing where the opportunities are ripe, and where they are ripe, and I'm sure there are other opportunities, they will act accordingly here. So I don't think these are sporadic.
Okay, thank you, and thank you everyone.